institution side, also on the government side, the experts to make their initial assessments. And somehow I feel that a lot of this is deliberate. There's just something that's not just. I mean, there's something that's not sitting right with me in this whole thing. Stuart wants to make light of it, which begs to this being something new. But like you said, for the amount of years that you've been inside the industry and others that I know, there are some things that should have been done, just generic, basic things.
Correct.
What is all, and obviously some people got to speak to some people over these things is my strong opinion on this. Thank you.
Okay, and correct, and I think I spoke on Inside Job last week. You have to watch that. Because like Eddie said, he doubt anybody going to believe it. Nobody is when Goldman Sachs failed. Guy got $30 million. People lost their pension, they lost their houses from Freddie Way and the credit crisis. People, millions of houses out there on the newspaper. And these CEOs got bonuses, and then they got hired to the Fed in the United States. Okay, you just caused a whole company collapse that was too big to fail, that the government had to bail out, and the same government that bailed their company out that's supposed to fail now appoint you to one of the highest positions in government. And so I go, they kind of manipulated the system because they know what you have to run. You got a network. Sorry about, and I think that's why I would say, only more people go to jail, so the record could reflect and do the good. But when it comes to just multi-millionaires, they never go to jail. They never pay bills. Nobody's running behind them to pay their loan payments. They borrow millions of dollars on the loan. They never have to pay them. Okay, Ashley?
Hi, yes, I'm here. Sorry. I agree with some of what he said, and a lot I felt as though he was trying to throw blame on other countries, like, oh, SEC couldn't find us, so how they expect us. But I still think we had a responsibility to do, I guess, more enhanced due diligence on the product and the actual person involved in the business, Sam himself and his other associates. I also agree with the corporate governance part of what he was saying as well, to go ahead and do your balance and checks. I believe also that they could have probably did, I guess you could say, continuous monitoring with their products and doing with their risk assessment when it comes to the products as well as, I guess, into the risk as well. Because I also feel though that with the government allowing this company to come over and do business, it is a territory that we aren't familiar with. However, we are familiar, I agree with you said, we are familiar with regulating financial institutions. So I feel as though they could have probably did a lot more research on cryptocurrency before they allowed it to come in the country the way that they did as a business. And if they did, so I feel like we probably would have been able to catch on a bit earlier to what was happening beforehand.
Yeah, yep, correct. And then because what is required when you hold this license, then you will see exactly why the Securities Commission should have caught on. Okay, so very good. Yeah. Toronto, is your mic working yet?
Yes, ma'am. I believe I'm on. Can you hear me now?
Yeah.
I had to chime in on my phone. This conversation is wrong. Thank you. You was up all the thank you. Listen, I just want to make just 3 points of notice. I want to go back to Brother Eddie as he commented with respect to Cassius Stewart. I believe that whole interview with Shanique, some of the views that he would have stated, yes, it was somewhat objective. Brother Julian, he also was just trying to throw in some, political nuggets in there. He's an opportunist, so I mean, I wouldn't expect anything different. But as it relates to this whole debacle, at the end of the day, I just feel like the Bahamas, in general, we just dropped the ball. I mean, I've only been looking into this whole compliance, you know, this whole compliance scheme of things for like the last 4 or 5 weeks, and I said, if you just stuck to the fundamentals, some things should have been pointed out very, very quickly. But I believe, like we always go back and say, it's better to do business in the Bahamas for good reasons. I believe that's why they moved their location from Hong Kong and they placed it here in the Bahamas, because I can't prove it. I'll just say an arbiter statement, but we always turn a blind eye to things, especially when we benefit from it.
And again, bribery and corruption, like persons who did their homework, very, very good homework, is very prevalent. And then persons who know that they can get some money on the table and they'll be accepted, they come in. That judicial system is backed up for years. It can take 10 years to sort this out. If they do something wrong, they come in. Okay? And what I learned is teachers back in 2018, a company there I did some work for, the biggest client was out of Antigua and Barbuda. And Central Bank had told us that, we had to send some of their money, and because it's too concentrated, meaning that if that bank had failed, the government of Antigua and Barbuda would have failed with all their eggs in one basket. So that was the first change that we had to do. We had asked them to take half of their money out, let's say send it to Scotia or Royal. So we lost a big chunk of money. Then Central Bank said they did a further investigation to find out that Antigua and Barbuda is a Schedule 2 country, which they don't follow all of the party recommendations. We have some AML laws in place, but not all of them. And so therefore, they are considered to be high risk, and countries don't do this, so them they will not. And we argued, Central Bank for months. And then they said that the decision was final, and we have let the largest amount go. Okay, because another problem was that we were doing corresponding banking for them, which meant that the person that went in and did it into the bank, and they didn't require you to bring out to send the wire or give wiring information like telephone number or address. And of course, we know, according to the rules for principles, we can't send a wire without an address. And most of the times you have to say the purpose, or you have to have some bill or some type of approval. And so we had to explain that the customer service people in Antigua that if you want us to be able to send wires, this is what you have to ask the customers for. If you're not prepared to ask your customers for this, then we can't send your wires. And so there was a lot of back and forth. Then they finally said, can you hire somebody in the Bahamas when they want to send the wire? And they will tell them what they put it in. And if the customers want to put it in, we'll say, but it is not that required in the Bahamas. So we had to set up the whole telephone number and line, and this person, with a lot of wires, of course, for businesses was still sent and they get compliant. And so that person who took those calls also kept all of the due diligence on the KYC in order to send those wires. Now, our correspondent bank with Northern Trust. Northern Trust came down and said that's nested, and that's against the law. They have to open up their own account and they're not unable to until they put their recommendations in place, until they follow our principles. And so along with that, that's the way Central Bank close out, tell us we have to let this account go. So what I'm saying now, that was in 2000, all of that to say, one of FTX, the second company, incorporated in Barbuda, which is still a schedule unless they kept updated with their how did we accept the house? Pennsylvania State closed that out in 218 out 19, 20, 21, 22, 4 years later. That a company incorporated in that jurisdiction was over. Okay, that's again. Because all of the regulators are supposed to be working together. They are supposed to, be on one accord. And if central bank puts down for a big and Barbuda, that means they should have sent word out that we can't open accounts from this jurisdiction and carry the update or their, so that was surprising. And again, watch inside a job. I
Good afternoon.
Good evening.
Good day.
Yeah, we had a little IT issue, but it's solved now. How's everyone?
Everything's good.
Wonderful. Y'all should be enthusiastic. Last class, yay.
Breathing.
Huh?
I say I breathing.
You breathing?
Yeah, ain't nothing good right now, Sata.
Why? What happened?
Cause our exam next week.
Man, you got this. You got this. Trust me.
You told us the same thing for the midterm. That ain't turn out too good.
No, but I would say after you did the supplementals, everybody passed.
I think
You're telling us everybody passed?
Yes.
Oh, I like
Okay.
that.
Okay.
Not
I
we're getting on to a good start.
Now, one person I didn't see me a supplemental was Sydney. Sydney, you send me something?
What? Yes, ma'am.
I gotta look for that.
Don't talk about them. I take
Oh.
take all.
If you mailed it, it's probably then I just didn't print it. I'll look for it. But
It's after the week. You saw mine, right?
else already done and you already passed. Don't worry about that.
Oh, thank God. Thank you.
Only Sydney. Sydney was the only person.
Only person who went off? What?
He didn't send me the supplement.
Hold on, not.
Sydney, I can look for it. If I don't find it, I'll just send you an email.
Okay.
Yeah, don't worry about it. If you did it, you did it.
Yes,
So
ma'am.
because if I don't find it and then I ask you for it, you have it, so you'll send it to me right away. So don't worry about it.
Yes, ma'am.
Yeah, but everybody else, I've marked them. Everybody has passed, and I have to go through my computer now and add on your points for when you submitted homework. So on the top of that, you still have an extra point for your homework.
Sounding good.
Okay. So let's do the last chapter. I think some people asked me to talk about CRS. They're in class today.
Yes, ma'am, that would have been me. I don't know. Oh, I haven't heard the term, so I wanted to know a bit about it.
Okay, all right. And you know what FATCA is about?
Yes, ma'am.
Okay, all right. So it's just CRS. So we'll do chapter 10, CRS, and then I will tell you all what's coming on the exam next week.
Okay.
Right. All right. So chapter 10, pay particular attention, because when we come to the final exam, you will see parts of it is in your final exam. When you look at chapter 10 covers everything that we've done in terms of the banker-customer relationship. So when you're talking about legal issues, defenses, and remedies, remember the cases that you have read, and you see like that's the hard trub of when a customer or the bank decides that they're going to bring an action. So the legal offenses and the remedies that are available in the customer relationship could be because of the action of the parties and how they operated the account. As you can see, sometimes when you have mortgages or you have loans that persons are not paying, they look at how the account is being operated, or they look at complying with the bank mandate. Again, you're looking at, you could use the case of Makushla and how, whether or not she was complying with the bank's mandate in terms of the PFSA. And then the bank has to try to mitigate its risk and any loss. So whenever it's either the bank or the customer, whether they're the plaintiff or they're the defendant, there are certain things that you have to consider when you're going to bring in a legal action. And that is, you have to look at how much is it going to cost to bring this action, which means that there are different routes that you can take before you go to court. And I think all of you are aware. First, the bank would do was have a conversation. Then they would draft a letter. So there are steps before you actually take legal action and go to court. Then you have to think about the time it will take going through the legal system to try to get a remedy for the action. Then you have to look at the publicity. And you can see that once a person loses, whether it's the customer or the bank, normally they would appeal. And depends on the court of appeal, they may reject it at the very outset, it's filed, or there is a hearing. And then the matter is again adjudged based upon what happened in the lower court. Then you have to look at the convenience and the inconvenience, because you have to call people to give witness statements. Then you have to look at their availability. And of course, you need a ruling. And sometimes the judge's ruling, you have to wait for it to be written in order to then decide this is the decision. And then you have to go back to the court to talk about cost. Who is paying what fees? So in most actions, dealing with the bank is a civil matter, and it could be for negligence. It could be for tort of conversion, as you know, in bailment, or it could be for breach of contract. But they're all civil matters. As you saw in some of the cases that we read, the bank also, before they bring an action, they have to conduct an investigation. And in that investigation, they review what the issue is. They then analyze it. They compare it to their policies and procedures to see whether the bank has made any mistakes. And of course, their internal legal counsel would then look at whether or not the bank itself has a strong position or a weak position. And that then again also plays into the consideration as to whether or not they're taking a matter to court themselves. If on the flip side, the customer is taking them to court, again, they have to look at whether or not it's a weak decision, a weakness in the action, or it's a strong one. Because remember now, if they take a matter to court and it is weak, they have to think about the reputational damage to the company. So there are legal issues that arise in banking law. And you can see from some of the cases that these are issues that the judge would summarize when he looks at what the complainant is talking about. So first, they look at the existing of the banker customer contract. So they look at the actual contract that the customer signed and the terms and conditions. Then they look at the breach of the bank's duties and they look at the breach of the customer's duty. They look at whether or not you can enforce the bank's right or you cannot. And the same is for the customer. Then they look at the breach of the duty of confidentiality. They look at the customer versus the bank's right to appropriation. Then they look at the rule in Clayton's case and whether or not it's operating to the detriment of the bank. Wrongful dishonor of a check. They look at the thought of conversion, safe custody, whether the bank did what it was supposed to do. Did it house the goods in a facility that protected it from damage? Did they make sure that the controls were in place in terms of accessibility to those goods that were being held in bailment? Then you look at defamation, whether when checks were returned, if the wrong comments were made on those checks. There are also legal issues come when you overcredit a customer's account or you overdebit a customer's account. And we had issues with ATMs. Again, you could use the case of Pinder. And then there are property issues. And property issues, I know you are common because the bank always exercises its right once the customer's in default. So besides breach of contract, negligence, and the thought of conversion, in contract law, and remember banking law is undergirded by contract law, there is what we call a mistake. Now, a mistake doesn't affect the validity of the contract, the banker customer contract. It has to be what you call a serious mistake of fact. And that could be that the signing of written documents could be a mistake, or the subject matter of the contract could be a mistake, or the identity of the parties can be a mistake. Those are serious mistakes. And once you have a serious mistake, then the contract is not valid. It's not legally binding. But a bank can recover monies for mistake if it pays a stop check, or it pays a forged check, or it pays a check with insufficient signatures, or it pays an altered check, or it duplicates payment. Everything depends upon the circumstances around the check. So in order for a bank to recover money paid by mistake, of course, you know, in law, nothing is outright. Everything is based on satisfying certain conditions. So the bank pays a customer's money to another person under mistake of fact, believing that the signature was genuine, but in fact it was forged, or having believed that a payment had not been stopped when it had. There is no requirement to prove that the bank was negligent in paying the amount, only that it had been mistaken in doing so. Or the bank pays without the customer's consent or authority. There's insufficient funds, but the bank believes that there are sufficient funds to cover the payment, or it pays a stop check, believing that no countermand is in place. Again, this is one of the conditions that the bank has to satisfy in order for it to recover money from the customer. And the last one is the bank pays the check and later attempts to recover the funds, but does not act with great speed. Because you know, in banking, everything is within a reasonable time. A bank may not be able to recover funds where it made a representation to the payee that it was making the payment and the payee changed his position in good faith. And this was to his detriment as a result of receiving the payment. So in banking law, if someone is expecting a certain sum of money on their account and the bank makes a mistake and sends that same amount to that customer's account, that customer knowing that they were expecting these sums, drew the sums off. And let's say the sums were already earmarked to pay a certain bill. And the customer withdraws those funds and pays that bill. Then the customer can argue that first, they withdrew it in good faith because they were expecting that sum of money. And secondly, that their position had changed in good faith. The second one is the bank may not be able to recover if it paid another bank as a collecting agent for the payee and the payee has withdrawn the funds. The paying bank can only collect money from the payee and not the collecting bank. Where the paying bank is unable to succeed in recovering the paid funds due to a mistake of fact, it may be able to exercise and enforce its right to trace. A customer is also entitled to reclaim monies paid under a mistake of fact. So if a bank mistakenly credited a customer's account, it may re-debit the account or claim any funds which the customer has withdrawn from the account. However, the bank may be prevented from recovering the funds if, again, the customer changes his position in good faith as a result of the credits that were mistakenly made by the bank. So mistake is a contractual term, but it is applied in banking law. Similarly with misrepresentation. And misrepresentation is an actual false statement. So whenever there's a misrepresentation, no matter which type of misrepresentation it is, the banker customer contract can be rescinded. That means it can be canceled or revoked. There are three types of misrepresentation: innocent, negligent, and fraudulent. Innocent is where a person makes a false statement and they had reasonable grounds. They believe that that statement is true when they made it, at the time the contract was being made. But the statement is false. But they're under the belief that it is true. So it's innocent. Now, if you make a false statement and they had no reasonable grounds for believing that that statement is true, then they're being negligent. And if they make a false statement and they know it is false, and they believe it to be false, or they just recklessly don't care whether or not it is true or false, they just make the statement, then it is a fraudulent misrepresentation. And once you make a misrepresentation, of course, you could sue for damages. And you do that under the tort of deceit. Now, there's also negligence. And negligence is a tort. And when a person is negligent, it means that there's something that they did not do. And you saw this term was used in the Pinder case, where they said that she was negligent. So it's to do something which one has a duty of care or obligation to do, but fails to do. And that's why I was telling you from when we first started the banker-customer relationship that you must know the duties of the banker and the duties of the customer. the rights of the banker and the rights of the customer. So in order to prove negligence, the defendant must have owed a duty of care to the plaintiff. And the defendant must have breached that duty to the standard of a reasonable man. And of course, the plaintiff must have suffered some loss or damage as a result of the defendant's breach of duty. So banks try to avoid negligence by making sure that their staff don't make negligent misstatements, or that they don't make any statements relating to advice with regard to investments, because then that becomes a professional negligence. Now, another term that you will see used in banking that is also a contractual term is undue influence. And this is where one person takes control over another person in terms of when they enter the bank, for example, for a loan, or when they come to withdraw funds with a relative. So what they're actually doing is they're actually holding back that person's freedom to interact and state exactly what it is that they want to do. And normally when you use the term undue influence, it has to do with that familial relationship, husband and wife, parent and child, priest and a church member, banker and customer. So when you have certain relationships, a banker always looks to see if there is undue influence. Someone is influencing someone else to make a decision that they do not want to make. And that's why you see when persons apply for a loan and they are of that familial relationship, they will ask them to get independent legal advice to make sure there is no influence. And again, another principle of banking, which is the last one, is privity of contract, which means that only parties to the contract can bring an action. If that person did not sign on to that banker customer contract, they cannot bring an action. And that's what privity is all about. So from contract law, you learn that there is privity of contract. You can have a contract that has been impacted by undue influence. You can have negligence on behalf of either party to a contract. Either it could be the banker or it can be the customer. You could also have misrepresentation in terms of how a statement is made to a customer or a customer to a banker. And then, of course, you also have a mistake. And a mistake, once it's a serious one, the contract is not valid. And you know from just dealing with pure contract that whenever there is an issue, you have to determine what that issue is in contract law. And the same comes to banking. What is the legal issue? You're looking at either the banker's duty or the customer's duty. You're looking at breach of contract. You're looking at whether the contract exists. And then you look at all the other main features of that banker-customer relationship, such as that duty of confidentiality. Can the bank enforce its right, or can the customer enforce its right? Can the bank exercise its right of appropriation, or can the bank exercise the rule in Clayton's case if it's not to its detriment? And of course, you also have to look at the ATM machine. What is expected of the bank? What is expected from the customer? when you advise, when a customer overcredits, when you overcredit a customer's account or you overdebit a customer, what is the bank supposed to do? What is the bank required to do? And the same way in which when you return a check, when a customer can sue for defamation, if you put the wrong remarks on those checks. And last but not least, we all know that banks provide mortgages and car loans. And there are remedies that are available for the bank when there is a default. Any questions?
Come on, it's pretty straightforward.
I see everybody is on tonight. Let me see if I have everybody here. I think so. All right. So now let's talk about CRS. Who can tell me what FATCA is about? I think let's start with FATCA. Just a summary.
I think FATCA is more so when you have U.S. citizens, is the foreign account tax, the foreign account tax compliance act.
Mm-hmm.
And basically, if a customer has U.S. indicia, U.S. birthplace, U.S. Phone number, U.S. address, basically we have to report it to say, anytime we find U.S. indicia on a customer, make indications.
Mm-hmm. And
Um,
what indication mean?
say again.
What's that indication?
We have to, well, and within our bank, we have to put notes in the system to say that the customer either has U.S. birthplace, social security number, and then we have to basically it has to be validated in the system.
Okay. And then report it.
Right, it has to be reported.
Okay. So what's CRS?
CRS is, I guess, more so the same, but for customers outside of the U.S. who file taxes outside of the U.S.
Mm-hmm. So there's a difference between the two. So that's the first thing.
Right.
FATCA, the U.S. only, as long as you have a U.S. indicia, a U.S. address, born in the U.S. But for CRS is every other country which that jurisdiction has signed an agreement with. So the Bahamas has signed an agreement with a lot of countries to release information on their citizens. So in CRS, they don't have individual de minimis threshold, which means that all the financial accounts of individuals in any jurisdiction that is reportable, they need to be reported. So if you go to the Bahamas Financial Services Board and then go under CRS, you will see a list of all of the countries that the Bahamas has signed an agreement with to report their citizens. And of course, between FATCA and CRS, there are some exemptions when it comes to investments. So FATCA excludes things like issued shares or listed interests in certain investment vehicles. And even in FATCA, it allows like insurance companies to ignore accounts by individuals. So they really only just looking for things over $250,000. But in CRS, insurance policies come within the scope. So it's a lot of differences between the two. And even with the Bahamas taking the approach, the wide approach, as they call it, using its intergovernmental arrangement, what the Bahamas has done is, instead of creating its own unique piece of legislation, the agreement refers you to the OECD agreement. And so that's the document that you refer to in making decisions whether you're going to report a person or not. So the Bahamas was not one of what we call the early adopters, like one of the first set of countries reporting, because there was a lot of issues surrounding which products are reportable under CRS. And then, of course, you had to determine who is going to report. Because remember, persons who bank in the Bahamas, they have companies all around the world. And the companies that are here in the Bahamas is just one or two or three companies that are part of a larger structure. So determination has to be made as to who is going to report, whether it's the Bahamas or is it another jurisdiction. So normally with CRS, they look at pre-existing individual accounts. They have to be over $1 million. And if it's a company account, it's over 250,000. So like I say, if you go on the Bahamas Financial Services Board website, you'll be able to see the list of all the countries that we have signed agreements with and that we are obligated now to go through and report them based on their balances. Any questions? No?
No, ma'am. No questions.
Someone said something.
No questions.
Oh, okay, that was just a background. Okay, let's talk about the final now. I just thought of another question I could add on this. Isn't that wonderful?
Another question you could add to the final question we already have? That's what you mean?
Another question I can add to the final exam.
How many questions do we have on the
I have
final?
7.
7 structured questions?
I have 7 questions, yes.
Not even bad.
And you're answering 4?
That's not bad.
Okay, I can make it 8.
For including the one you already sent us or for excluding
No,
that?
excluding that one.
Okay, so we have to answer 5 questions in total.
But that one I gave you, you should be finished with that by now. Okay, so let's go to the 7 questions, or should I make it 8? Let's see. This is the one I want to add now. Tell me if you want it on or not. Should the Bahamas eliminate exchange control, and what will be the impact on the banking industry?
We need that.
I actually like that.
Okay.
For me, I can't think for everything.
No, but I mean, everybody don't have to do it. I'll add it on.
What you said it was again? Should the Bahamas eliminate exchange control and
How will it impact the banking industry?
When you said Miss Archer, like you referring to like how with central bank and stuff like that, right? Like
Mhm.
report the central bank. That's a good question. That's a good discussion, actually.
Of course it is.
I like that one too.
Because you can think about it from now until next week, right?
Yeah,
If
and
we
you could do some
can.
research.
Of course. All right. So that's one question. I'll add that on. So now there's 8. And you choose 4. See, that's even better, right? All right. So that's one question on exchange control. Then I have a question on mortgages.
No mortgage questions, please.
You don't have to answer mortgage question. When you finish writing down what I say, then you could decide what you want to focus on. You have to choose 4 out of 8. Isn't that wonderful? Say no mortgage question. Okay, so the mortgage question is just for you to explain what is a mortgage. How does the bank take on a mortgage of unregistered land? Do you know what unregistered land is? Everybody knows what unregistered land is?
No, ma'am.
They call acquiring or what? That's not required.
No, that's not quiet. Quieting is when you fence in and farm on a property.
Okay.
Yeah, no. Unregistered land is all of our land in the Bahamas. Unregistered means that the land itself is not, knowing who the owners of the land is not automated. So in other jurisdiction, if you see a plot of land, you can go to the registry, key it in the system, and it will tell you exactly who owns it and give you the whole history of who owned that land. But in the Bahamas, we have unregistered land, which means if you see a piece of property that you're interested in, you then have to go to a law firm who conducts a title search and goes through that whole process to find out who owns the land. So that's what we call unregistered land. It's not automated. It's all manual. And then the third part of that question asks you, what are the rights for repayment? Which means that if a customer does not repay their mortgage, what happens? What remedies does the bank have? So that's one question. That's a mortgage question. That one sounds good? I ain't getting no answer.
Not at all.
Yes, I like this one. The mortgages is a good one. Yes. I don't know why the rest of them running from mortgage. Okay, so now let me give you another one. I have a question on undue influence. So this question has a copy of a letter coming from a client who wants to borrow some money. And they are suggesting a guarantor. So you have to talk about what's the legal position after you read the letter, legal position of the bank, and talk about what are the principles involved and what kind of decision you would make. But this is a client looking for a loan. That sounds easy, right? No, yes.
Yeah, this one doesn't sound so bad either.
No, I'm telling. Let's see. The next one. The next one is on a joint account. Two single people, they open a joint account in preparation for marriage. And then the man leaves her. And there is a little bit about where the funds came from. And you have 3 questions to answer. How are you going to deal with it? What approach you would take if certain things were absent? And then what approach would you take if the funds came from a different source? So that's a joint account. That one okay? Easy peasy.
Yes.
Jack. All right. Then I have a question on ATM. Very simple question on the use of an ATM that disperses the incorrect amount. And of course, you have to speak about the legal obligation of the bank to the customer and the liability to the customer on the use of the ATM.
Ms. Archer, repeat that again, please.
It's an ATM question where the person would have access, put in the request to access funds and the ATM dispersed less than what they asked for. So you have to speak about the legal obligations of the bank and also the bank's legal obligations and liability to its customer, referring of course to the customer contract. So I just use a different scenario, but you could also look at the clauses in the PFSA in the Pinder case. The next question is about money laundering, knowing the process, and looking at the products and services that financial institutions offer and the risk that they pose to the institution because of money laundering. How many is that so far?
6.
Okay. I have another question that has 2 parts. One is about accounts, 2 accounts. Knowing the requirements or the formalities to open an account for a partnership and a limited company. And the second part gives you a scenario on joint and several accounts.
Can you repeat that one, please?
Part 1 speaks to the formalities for opening an account for a partnership and a limited company. And the second part speaks to a joint and several account.
Thank you.
And the last question, of course, you know, it's on the case of the Court of Appeal case of Scotiabank versus Pinder. And in this one, you will discuss the legal issues that arose in the case regarding the duties of the bank and the duties of the customer. You'll also discuss negligence and what should be considered by the respondent and the appellant before commencing an action.
Can you repeat that, please?
All of it?
Yes, please.
Okay, so you're looking at the appeals case of Scotia versus Pinder. You're going to be discussing what are the legal issues, bearing in mind the duties of the bank and the duties of the customer. You're going to discuss negligence. And you're also going to discuss what should be considered by both the respondent and the appellant before commencing an action.
That's before taking legal action, correct?
Yes, before you take legal action. And that's your exam. Now, at the very top, you'll see on exam, it says, use case law and legislation where applicable. And those words are not there for pretty. So I know a lot of people just like to write their feelings. So if you're going to start talking about customers' duty or a banker's duty, you know you have to quote the case of Jahimson versus Swiss. And if you know the document for your organization that refers to those same duties as a part of the contract, such as the PFSA, then you go from the law to the actual working document. So you have enough time now to sit down and figure out how you're going to approach your questions to make sure that you can get your full points. You can't expect to get 20 points by writing 4 sentences. So you have 3 hours. Take your time and write your answers out properly. Any other questions?
No, ma'am.
Okay, so I'm going to wish you all luck. I'll collect those exams on next week, Wednesday. So I can start having a look at them. Now, anybody who finishes their paper before can send it to me so I can mark it.
When you say send it in, what you mean?
Email it to me.
Questions?
Email me the paper. So it's Sydney. I have to look for your supplemental and Davisha. Did you send me one?
I did, but I could send it again if you need me to.
Okay.
I could send it.
Okay, it's just the 2 of you and that's it.
Okay.
Okay.
Miss Archer, a question. So because I hear you say just now we could send it to you if we finish it before, so we don't necessarily have to go in for the exam.
What you mean?
Which
You
paper
only
you
said,
Shawnee, that's our,
one take home question.
yeah, that's our taking question for extra points, Shawnee. That ain't the exam.
Okay.
Yeah.
Okay.
Yeah, you have to go in and take, no, now don't say for extra points, not extra points, but hopefully you will get full points for the take home final exam question. The one where you had to do the research about the discontinuation of checks.
Hold on, so I confused. So the research question is a part of the exam then. So basically
Yes,
that's okay. Okay. All right then.
Because I given you all a chance to get at least 20 points, 18, 19, 20. If you've done your research good, so you've already started and you have 4 more questions to when you get in the exam.
Okay, that sounds good.
Okay, so you have a good chance. Now, if you decide to do your research question Monday night, when of course you know, and you just starting your research, it won't be ready. So that's why I give it to it enough time. You could do your research, have the bibliography in the back on your last page, and give me your opinion, what you think. So it's not a whole Bible you're writing. The bibliography may be longer than that, maybe 3/4 of a page, because that may be how much research you did. But when you summarize it, you're just giving your views. Either you're of the view that the central bank is taking the right decision. And remember what I told you all, you could have gotten statistics from your own organization. Have they seen a decline in the uses of checks? And then you could compare that to other jurisdictions that have already made that decision and look at what did they use as a premise for discontinuation of checks. And then you could do a recommendation as to what the central bank may do in the next year to 2 years, or maybe even shorter term. So that's up to you, how you write the paper. But you have an opportunity to get 20 points. So everybody's happy now? Yes, no, maybe so.
Yeah, sounds good. Once no multiple choice, we can live with that.
There's no multiple
Yes,
choice
ma'am.
here at all. The same questions I told you, that's what's on the exam. There are no surprises. None whatsoever. So the ball is in your court. Even the money laundering question is relatively easy. For those who read the both the Supreme Court and the Court of Appeal case on Pinder, that's another giveaway question. The one on the ATM machine, another giveaway question. So that's already three easy questions. And then depends if you don't want to do joint and several joint accounts, you have the exchange control question to do. Because you know, right now, when a person wants to go away, they have to come bring the passport, the ticket, and you're all writing it down on the form, all of that foolishness. And then anyone who's interested in doing this, you could go to the central bank, go to exchange control, and you'll see where over time they've been relaxing a lot of their approvals. Because before you used to have long lines to the central bank. The person's coming for approval, domestic and international. But that doesn't happen anymore. A lot of that has been delegated to the banks. So if you were now to look at what has been delegated and see how it impacts your organization and what would happen if it was eliminated. Would it affect income? Would it, from a customer standpoint, make doing business easier? All those things you have to think about. And there are articles on it. So everybody's happy now, right? I ain't hearing nothing.
Yeah, everything sounds good. Sounds in order.
Okay, all right. So then I expect to see some good papers. Some very good papers. All right. So everybody get cracking. Don't disappoint me. How that sounds?
Sound too excited.
I love reading good papers.
Sounds good.
Yeah.
Yes, I'll try not to disappoint.
Okay. All right.
All right.
All right. So I'll get those papers. Like I say, anybody who finished their research paper before can send it so I can mark it. All right.
Wouldn't send it back if we could get more points.
This is a final exam research question. Let me tell you what I'll do. If you send it to me and it's rubbish, I sending it back.
Okay.
How about that?
I sound good.
Okay. So that's why I say, if you started early and you send it and I read it and I say, well, what the hell is this? I'll be sending it back. So you'll have sufficient time to do it over. Because you may be thinking you're on the right track and you aren't. Okay?
Miss Archer.
Yes, my dear.
Because we wouldn't be able to speak with you next week, would it be possible for you to send a confirmation to say you received the papers, please?
Yes, I can do that as I receive each one.
Okay, thank you.
That's no problem. I'll write it right here and right on my draft exam paper. Okay, I got that. Anything else?
Miss Archer, is it possible, right, that I could speak to you in reference to my mortgage? Well, it doesn't really have anything to do with class, but I just had a few questions that I wanted to ask, if it's okay. Outside of class.
Oh, okay. All right. You want to call me tomorrow?
I can, if I could get a contact for you, please.
Okay, 805-2372.
805.
Again? 805-732.
Are you getting this? You are not in this. 805-2372.
Okay.
All right.
Thank you.
We'll be in contact.
I was saying the same thing.
What's
Switch,
going
We'll
man.
be in contact.
Are you all these people?
Yeah, you can come to us and we treat you good. Lowest percent, you know. We got you covered, man. No, Robert, I that's a referral from me to you.
Yeah, man, send it.
Yeah, you could help Mr. Steve,
Thank you, Ms. Archer.
These Scotiabankers is something else.
Either you want the money or you want the money. You got to be serious for the money.
And Mr. Steve, you get a little bit of cash back, put in your pocket, have a nice Christmas, you know what I mean? Everybody win, man.
Oh, Lord. That's a heavy debt. That's a 20-year debt. Sure, you want
Come
that?
on, that ain't a 20-year debt because your payments could be feasible where you could apply principal payments. Just think good sense.
Mm-hmm. How much
Yeah.
principal pay?
I think it's 15% annually.
Annually?
Mhm.
Yeah. Well, that only depends if you get that money in hand.
We'll further discuss.
Anyhow, Nadia, give me a call, please.
I will, yes, ma'am.
Okay. All right. Anything else? Anybody else? No? All right. So it was lovely teaching you all. I wouldn't see or hear from you all again unless you take another class that I teach. So it was quite enjoyable. I could say at the very beginning, you all struggled and afterwards you caught on very well. Focus and you all worked hard. So I know for the final exam, you all will do well. So if you feel like a challenge, once you finish this program, you could come to one of my company law classes. Or if you decided you want to go the compliance route, I'll see you all in ICA. Or if you feel like doing risk, I will see you all again in risk management. Or if you all decide that you want to become professional advisors, I'll see you all in the Certified International Financial Planning course.
It's Ballard, what you don't do. I mean, Mr. Asher, what you don't do.
What do you mean? There's plenty of things I don't do.
Come
I
on,
only
man.
teach
I'm sorry, you're doing everything. Why you still working? You should never be working after one 5 years.
Why?
All those I'm glasses you teaching. And then you have an additional job apart from that, eh?
Yes.
Come on, man. You shouldn't be working no more.
Why not?
Your money should be working for you now. You should already have persons in place to take over for you.
I'm training some people.
Okay, then. I'll be there on Monday as well.
All right. So get started. No excuses. And I don't want to hear nobody had no mind went blank. Okay. Keep hearing that. All right. So anybody have any questions, you could send me an email or you could call. But if you know, text is better. Because once you text, then I can see it and I can call you back if you give me your number. All right.
Yes, mom.
Okay.
All right.
All right. So enjoy the rest of your evening.
Thank
All
you.
right,
Appreciate
Miss Archer, thank you. Appreciate
All
it.
right.
All right.
You too.
No.
Okay, good night.
Good night.